Good afternoon, everybody. My name is Manohar Samal. I welcome everybody to the Global Law Assembly Conference 2022. Uh, we are here to discuss India as a neutral hub of ADR, solving national and global challenges for domestic mobility. We have with us three eminent panelists. The first speaker is Mr. Girish K. Mishra. Uh, Mr. Girish has about 23 years of experience and a specialization in arbitration, corporate insolvency, and in the field of litigation. He has been conferred fellowship in various international arbitration institutions, like the Chartered Institute of Arbitrators and the Malaysian Institute of Arbitrators, to name a few. He is an empaneled arbitrator with the Scope Forum of Conciliation and Arbitration, New Delhi, and he has been handling high stake arbitration disputes. He has handled a number of arbitration matters for the National Thermal Power Corporation as well. And he's currently the legal head of Kanoria Foundation, which is a fountainhead of various investment companies and NBFCs. I welcome you, sir.
Thank
Uh,
you.
our second eminent speaker is Dr. Anirban Chakraborty. Dr. Anirban's career in law spans over 18 years, and he has experience of working in diverse settings. He started off as an advocate at a solicitor firm at Calcutta and switched to academia in the year 2005. His career in teaching started at West Bengal NUJS, where he served for 12 years, after which he shifted to MNLU Nagpur, and currently he is at Nalsar, Hyderabad. He has also worked as a manager for the United Nations Development Project under the Access to Justice for Marginalized project and as a consultant to the Department of Justice, Government of India. He has also been awarded the Fulbright Fellowship in the year 2009. I welcome you, sir. And our third speaker is Mr. Ish Jain. He is an international arbitrator and mediator and is empaneled with almost 25 institutions, including the Asian International Arbitration Center, the London Court of International Arbitration, the Saudi Center for Commercial Arbitration, the Russian Arbitration Center, Russia, just to name a few. He has also been designated fellowships from various institutes, such as the Chartered Institute of Arbitrators, the Hong Kong Institute of Arbitrators, the Arbitrators and Mediators Institute of New Zealand, to name a few. I welcome you, sir. So, as an icebreaker uh, point of discussion, I would request the panelists to begin with enlightening us about the evolution in arbitration and mediation in the last decade. And from that, we can take the conversation forward.
May I start?
Absolutely, sir. Absolutely.
First of all, it's a pleasure to be here with the distinguished panelist. And for the first time, I'm meeting Dr. Anirban, though I know Mr. East Jan connected through LinkedIn for a long time, but it's the first time that I have been, able to interact with him and sit in a panel.
It's
So,
a pleasure. It's a pleasure.
thank you. If I say last decade, in fact, the development of arbitration, if you see, started almost from the uh, 1996 Act of Arbitration. In fact, though we had Arbitration Act since 1940, but the status of arbitration in 1940 Act was something which has the status of mediation today, which requires the courts rule to make it enforceable. Earlier in 1940 Act, if we take the status of arbitration, but under the UNCITRAL developments, India has been very quick to take those international developments insofar as arbitration law is concerned. And at least on a legislative level, the legislature has been very, very quick to pick the developments and at least show to the international community, business community, the transacting community that insofar as law is concerned, India has been quick to modernize its act, and the legislative intent has been very, very prompt. But the question remained, of course, insofar as practical aspect is concerned. Practical aspect, even in 1996 Act, was that initially the court had a lot of interference in the appointment process in Section 34 under the Section 34 provisions, and that was in fact robbing the very spirit of arbitration, which though was reflected in the legislative intent, but on a practical aspect, somehow the parties were not feeling comfortable. Subsequently, in 2015, 2019, there have been several amendments, and India has been able to correct those loopholes, the problems which was actually creating problems. So, but the ADR process is not all about arbitration. It includes various other modes of the dispute resolution mechanism, primarily being the mediation, conciliation. We also have the other mechanism called Lok Adalat. Now, Lok Adalat and mediation, these two aspects of forms of dispute resolution mechanism have been mainly guided by the court. The mediation process, where court has referred the parties to the mediation, in those areas we have found that the parties sat before the mediation committee or mediator, and the report was sent to the court. And in those areas of dispute resolution, we found that the success rate of mediation was almost 100%, because the report of mediator going to the court almost resulted into taking those mediation settlement as a decree of the court. And in those areas, the mediation has been actually working very, very successful. If I may give an example of mediation center running at Delhi High Court, I mean, the success rate is so high. If somebody visits the mediation center, mediation cell, one could find that the people over there, the gathering, the number of mediators, number of parties are almost equal to something which one could find in the courtroom. So people actually have started accepting those forms of the mediation, and they have actually opted for parties to be sent to the mediator, and the mediation has been acting very, very successfully. But mediation as a whole, in order to make it very, very successful, uh, this actually has to be given a little wider, application. It should not be limited to the something which is where the court refers to the parties to the mediator. Rather, in the line of the arbitration institutions, there should be, and the institutions running the mediations also, and where party could freely, without going to the court, could approach mediation center and refer their disputes to the mediators, and at the same time they can seek their dispute resolved through the mediation process. uh, Mediation has been equally popular. I mean, in last decade, if I have to take, I mean, that's the subject matter today. Mediation has been equally popular, but it lacks little teeth also, in the sense that the arbitration, uh, the award is the decree of the court. It could be executed as a decree of the court. It can be directly put to execution without seeking rule of the court. At the same time, if you compare with the mediation, the settlement, it actually requires, uh, you know, to be declared as a rule of the court if it has to be enforced. Otherwise, if it is not declared by the, as a rule of the court, in that case, what any person can back out. There is no mediation law. I mean, there is no legislation as such dealing with the mediation process, and therefore there is no, the agencies as such, specialized agencies dealing with mediation process. There is no proper rules as such formed to basically govern the mediation process. Uh, and therefore, what we actually need is the proper law. At the same time, a proper the machinery to deal with the the mediation process, and also the enforceability of the mediation thing. So, I mean, I would say in the last decade, the the developments have been positive, in the sense people have been actually opting to mediation process. If you also see the section 89 of Civil Procedure Code, uh, there is a provision where even if a party approaches the court, one could really seek before the court that matter be sent to the the for the uh, ADR process to be resolved. And if at all party wishes to have the matter sent to the ADR process, then there is a liberty that the court fees, whatever a party might have filed in the court, could be refunded to him. So refunded to the party. So in the legislature had encouraged even in CPC that if a party files a case, happens to file a case, still has the room to have the matter referred to ADR mechanism for its resolution. And there are certain benefits attached to it, that like the huge court fees. Sometimes it is almost equal to 1% of the claim amount. So that court fees may be returned to the party. So the legislature has encouraged these things. But when it comes to practically see how these things are being opted by the person, by the party concerned, there are certain more things which are needed. Now, one more example I would give you is that whenever we give a legal notice to other party, in the end we say that unless you comply with the demand made in the legal notice, the party concerned shall be constrained to approach the court of appropriate jurisdiction under civil and criminal legal remedy. We do not write over there that party under the civil remedy, it is not only the court, but it should be rather also open to the party to approach the ADR, the agencies. And it should also not be limited. I don't know to what extent the legislature is going to agree, because international community also always emphasize on there being a written agreement insofar as arbitration is concerned. Unless it could be even oral agreement, but they emphasize on an agreement. But insofar as civil court and the criminal court jurisdiction is concerned, it is not open for any agreement to be entered into the parties. Now, can we have that kind of arrangement even in relation to ADR process? A party, a person who issues legal notice, or a person who has the grievances, has the option in a very first place to invoke ADR, either of the mechanism given in ADR, and once invoked, then in that case, now the Supreme Court has also corrected the the problems where the earlier you see the standard clause of arbitration was that the sole arbitrator could have been appointed as the instance of one party. Now that gave a little room, an area of some biased the award. But those things have been now rectified by TRF judgments, and subsequently there have been so many judgments, including protractor judgments of Delhi High Court and Supreme Court also, saying that in case there is a provision of sole arbitrator to be appointed, it cannot be appointed by one party. There has to be the consent of both the parties if the parties appoint the arbitrator, else it has to be appointed by the Honorable Court. So that area has also now been rectified. So coming back to the issue which I raised, the option available with the party and the option to exercise which forum a party may go to approach for the purposes of resolution of dispute. I think it should not be limited only to the court, but should also be parties should also be amenable to invoke the different mechanism which is provided under ADR process, like for example, particularly the arbitration and mediation, both. So once having invoked the arbitration, even if there is no arbitration clause, and since there are authorities in place, there are act in place which will ensure that a transparent, free and fair arbitrator could be appointed, there should not be any doubt for the other side to go and challenge that, since merely because there was no agreement, the matter could not have been referred to the arbitrator. So those areas need to be little rectified in order to make ADR little more popular, and certain legislative intent also need to be put in place insofar as mediation and other forms of, apart from arbitration, other forms of the ADR process is concerned. Because once you attach the legal sanctity, if you add the enforceability power in a particular settlement thing, then only people are going to really invoke those areas of ADR and resolve their disputes. So we need to come out. ADR has definitely given a very good platform to the parties who have been actually seeing that how people run around the courts for 20 years, 10 years, 15 years, and even 25 years to get a justice. ADR different forms of ADRs have definitely provided a better option to the parties today. Particularly, the commercial communities have been taking great deal of advantage by putting arbitration clause. They put adjudication clause also. They also have the clause dealing with the provision where they can amicably settle the dispute between themselves. So all these are ADR process, and the community, transacting communities, business community, commercial communities, even individuals have been taking advantage of these things. And for last 10 decades, I would say India has definitely worked, progressed tremendously. I mean, if I may just give one example of MCIA, Mumbai Center of International Arbitration, recently coming out with the news saying that in 1 year itself, last 1 year itself, the total claim, which was actually adjudicating through arbitrator using MCIA, was more than US dollar 500 million, if I am correct. So that actually shows, the great deal of encouraging, the factors and regions. There are so many other arbitration institutions. Delhi International Arbitration Center has also come up with the premises of Delhi High Court. If you go and see, they have modern techniques, all those technologies in place. Uh, Good many numbers of competent arbitrators already impaneled. There are cases in Delhi High Court where people opt for, even if there is no such provision in the agreement that matter will be sent to DIAC arbitration. Still, sometimes I have seen even the court encourages the parties that why don't you go to approach the DIAC arbitration for your settlement of disputes. And I have seen that parties have been going to DIAC, approaching DIAC, and having their dispute resolved there. In one of the cases, it happened with me as well, though my client did not support to that. So that's a different thing. But I could see the approach of the honorable court, that if party could want their dispute to be settled by DIAC, they could have gone there. So they are providing competitive the fee structures also. So I would say a lot of developments have come up in last decades. A lot of arbitration institutes have come up. They have started impaneling arbitrators. They have the all the means to see their standards of holding dispute resolution thing at par with the international arbitration, the institutions. And even the legislative intent I have seen, I have explained, are there to support the development of arbitration and India as an arbitration hub. If you see the whatever limited area in which court operates, insofar as ADR, the thing is concerned, particularly the arbitration, I would say we can safely say that Indian courts have shown much resilience and impartiality. There have been so many judgments, particularly the Amazon judgment, the emergency arbitrator award, which was passed with Singapore. It was an award in favor of the outside entity as against the Indian entity. And the Indian courts actually shown to the whole world that we don't act, partially. We don't do partiality insofar as handling the thing is concerned. Even if there is no provision dealing with international, the emergency arbitration award, still we could apply, the R process at par with the international standards, and the judgment which came up is the history today. So courts are coming up, legislative intent is there, arbitration institutions are coming up. They are all equipped with the modern technology. I would say in that limited area, I would say for that limited region, I would say thanks to COVID, because the archaic sector of Indian court system has also now started adopting and adapting to the modern techniques. More and more lawyers are coming up and arguing virtually. Today they are forced to argue virtually only because there is no physical presence. So all these techniques are being taken up, even in the ADR. ADR, in fact, is the front runner insofar as adopting the new techniques are concerned, because they are the new entities and they are better equipped. They show that they are better equipped to handle dispute resolution using modern techniques. So there is another Niti Aayog proposal which I could see, which is in relation to online dispute resolution, the system, ODR. So so there are systems in place. I mean, Niti Aayog is also working. So I think in last 10 years, if I have to pick up, I would say a lot of developments have taken place, and in future, I think it has a very, very promising things to come. This is
Yeah.
what is.
Thank you, Mr. Girish, for your exhaustive view. Uh, would any other speaker like to comment on this before I can take the conversation
May I?
forward? Yes, yes,
May I?
please.
Firstly, I want to thank the organizers of this program for inviting me, and especially, you know, it has been a problem in this country that whenever we talk about things like, connected to more on adjudication or, judicial administration, one part of our legal profession or fraternity is ignored, and that's academia. So at least this forum has not ignored an academia, and I am an academic unlike my other co-panelist, and I'm very glad to be part of this panel and share the dais with people from the industry, and they will provide the industry oriented views, which is a very good input for even us who are day to day handling things in preparing those people who are going to go to the industry in future, and going to strengthen their hands in the industry. So this industry academia bridge is necessary somewhere, which was lacking, but I agree with Mr. Mishra that in 10 years time, this is one very positive development. Yet I have uh, I don't you know like to start sounding a little negative and critical to this whole proposition of 10 years success, but just taking one step behind. If I have understood correctly, Mr. Mishra, he was talking about this involuntariness in theory of the ADR processes, maybe one of the reasons to somewhere less adoption, or not being able to kind of cope up with the litigation, or the adjudication or dispute resolution other than litigation not picking up to that extent. The involuntariness of either so-called the non-adjudicatory ADR, or even in arbitration, the reason, I mean, the need to have an agreement in writing, or the other formalities that are associated with it. But I like to just take one step back and just put this question. Uh, Along with the 1996 Act, we had arbitration, we had recognition of foreign awards, and we had a part called conciliation. And it was also enacted based on the ancestral rules, not the ancestral model law, it came later, but ancestral rules. And I from the beginning have not able to understand this artificial distinction that the Indian legal system has made between conciliation and mediation. My training in US has never told me to differentiate this. Maybe on the approach of mediator we may have some distinction in terms of the nature in which the mediation process to be conducted, or the ethical, or so-called the ideological stand in which the mediator engages. But this artificial distinction that was made to justify this distinctive four processes in section 89 post the introduction of the 2002 civil procedure amendment was something amazing to me all the time. But luckily, in the recent legislation, or the draft legislation which was introduced for public comment by the ministry, they themselves had acknowledged the fact that conciliation and mediation is not different. Similarly, the Singapore Convention, which talks about enactment of conciliatory or mediated settlements of international nature to be enforced, like we may say draw an analogy with the New York Convention, also does not create a distinction. Now, if we look at the scope and the nature of the conciliation part, I think it does talk about agreement is necessary, but it does not talk about the way that it has to be a pre-contracted agreement or something like that. Similarly, it also creates a enforcement mechanism, but still, why conciliation has not picked up? Why conciliation has not been used to that extent or popularized to the extent as we have arbitration,
Yes.
though both having being in the same time in the statute? So these are some questions that allows me to open the point that I always say in the class, that there is a problem with our system in two ways. One, our legal education or our model of the academic engagement in preparing our lawyers. Somewhere we kind of put in their mind, and I quote here an American former Chief Justice, whom I often quote in my class, Justice Warren Burger. And he said that our legal education and our professional outlook has been to prepare, combatants of courtroom battle rather than healers of human conflict. And I always take this as a starting point where we have deficiency as an academic, as a legal educator, or in our legal education system, to give the kind of mindset in our future prospective lawyers. So one, and second is mindset deficiency, which starts from the law school and carries to the profession. I have conducted and I've engaged my students to conduct several empirical investigation in terms of the acceptance of the legal profession about this ADR. And somewhere I have found that other than public meetings where they are all flying about the benefits of ADR, in their real work somewhere they themselves are not also very confident uh, about the utilization of ADR. And I have seen many senior counsels do not, kind of to that extent, advise their clients for, arbitration, yes, but to non-arbitration based other ADRs. So that is another, problem that we have to also consider in our, our inquiry as to why, or how we are going to overcome the ADR issue. Third is training. Now, we talk about continuing education as one of the ways in helping our profession to cope up new challenges. Now Supreme Court, uh, with all due respect, had created a model of training for people who are going to engage in mediation. But I do have my reservations, and some senior mediators of the country has also, how can you prepare a mediator in 42 hours? And a mediator who is prepared in 42 hours, will he be able to understand and engage in the mediation process in the manner which is required? So that is also something I want to put as a highlighter before this forum to begin with. And the last point which I wish to make here is you know this overemphasis in every sphere of our life. I'm meaning your professional life of a legal of lawyer, on reliance with adjudication. Now I always give a small example from one of our very eminent judges who have been very very proactive for ADR, Justice Ravindran. Now he said that if we have a place where we have a super surgical hospital which is catering to the health needs, the only way of catering to the health needs of the entire community of that area, will it meet the health needs of that community comprehensively? And the answer is obviously no, because not everybody requires surgical intervention. It's only very limited. But when we draw that analogy to our legal system, somewhere from the beginning till lately, I agree here with Mr. Mishra completely. Till lately, it has been an emphasis on litigation as the end of everything. So it's the only mode of treatment of any kind of dispute. So that mindset has grown into our mind, and at least our generation and Mr. Mishra's generation, I'm, at least from the appearance of Mr. Jain, it seems that he is much younger, or you. At least our generation, our law training in our law school, our professional engagement to begin with, has been too much this combatant of court battle orientation, and we are carrying that baggage, and that's why our adoption has been much slower. So we need to address that, not just by making legislative changes or some judicial attitudinal changes. And I agree with the point that there has been a constructive judicial attitudinal change in the recent. But even in 2013, Law Commission of India in 246 report recommending for bringing this emergency arbitrator, why it took 8 years for the Supreme Court to admit. And in between there are at least 10 cases which can be from various high courts, and even one in Supreme Court can be cited where they have denied. So in 246 report, Law Commission said, in 2009 people have said, so why in 2022, when emergency arbitrator has become a part and parcel of the international arbitration community? And in 2016, all the major arbitration institutions have changed their rules. And earlier it was like you have to opt if you wish to have an emergency arbitrator. Now it is opt out. Emergency arbitrator is default. If I'm correct, I'm not a practitioner, so my friends from the practice may correct me. But as far as I understand, the ICC, LCI, on their rules are now opt out. So why it took 8 years for our Supreme Court to realize emergency arbitrator's value? Yeah, better late than never. But why? So obviously, still we are of that generation who carries that baggage. I am convinced on that. So how do we deal with this baggage? That is also a very important aspect. And the last is, I refer to another academic paper. Being an academic, Professor Frank Sender, who was considered to be the father of this so-called modern, American movement for alternative. He wrote a paper on varieties of dispute resolution. And there he kind of, after analyzing these various dispute resolution and looking at this the importance of case management or dispute management, he said that ADR plays a larger role, not just in, dispute settlement. It's a dispute processing, it's a dispute management, it's a dispute prevention in, mechanism. So proper utilization. And he said very emphatically, after empirically looking into the working of the various institutions in US, that ultimately it is mediation which should be the default process. But how many of our lawyers in this country, and even the judges, with all due respect, would be ready to advise? But I know in United States, the American Bar Association makes it mandatory, and there has been at least 20 professional negligence cases where the councils have not advised for mediation to begin with, or a sort of non-adjudicatory alternative dispute resolution to their client. But how many? And even, if some of us do advise, maybe our Bar Council of India will come up with a black, flag protesting that what is happening. So these are some baggages, these are some questions which we cannot ignore. Only legislative and judicial change, to my opinion, will not address. But I'm happy that this discourse has started, and I agree 10 years we have progressed, and I'm hoping, and I'm a very optimist, though I belong to a little bit older generation, but I'm optimist that even we have started adopting, so younger generations will be much more forward. Thank you.
Yes, thank you for your views, Dr. Anirban. Anything from Mr. East Jain's side, or can I take the conversation forward?
Just so Mr. Girish and Doctor have actually summarized everything that was to be said exhaustively. Just want to add 2 points to it, and that's just to emphasize on what both of them have said. With respect to mediation, I think to answer Doctor's question, mediation is while being a mediator myself and seeing the mediation world from inside, I agree with Doctor that a lot of lawyers do not suggest mediation, and that's to do with the traditional mindset and the baggage that is carried by the older generations of not suggesting mediation to their clients. But the predominant problem does not lie there, because it's not within the lawyer's capacity or hands to restrict a party from going to mediation. And that's what I've seen, that even if the lawyers are reluctant to send the parties to mediation, if the parties want mediation, they have time and again changed the lawyers because the lawyer has not recommended mediation. The problem in mediation is not with the lawyers primarily. The problem with the mediation and in the course of mediation ahead is the parties themselves, and that's not to do with any generation so far as this issue is concerned. but it's more to do with our cultural setting. If you look at the US, there is not a lot of relations between a lot of people. I mean, it's more formal. You do not have communities over there. You do not have business transactions within the community. Today in the gold market, you will see all the Jains and the Marwadis. You will see in the grains market, you will see all the Kachis and the Gujaratis. So each of these there are these other sectors in the south. You will see again gold market, a lot of South Indians are there. So all these regions have their own business communities which are there. Now what happens is, when a dispute arises between the traders, or the consumers and the traders, whether B2B or B2C, they normally tend to refer the disputes to somebody from that community. And when the disputes are referred to the community, that first step towards mediation is already taken by the parties. And it's only when that mediation step fails that they go to the lawyer to resolve the disputes. Today, that's the general tendency of most of the people who are litigating in India. Now, uh, what Mr. Mishra has said is true insofar as the corporates are concerned, but today corporates may amount to a large quantum of disputes, but so far as the quantity is concerned, corporates amount to hardly 5% of the backlog and the clogs in the courts. The majority of the disputes are taking place between the common people, and those are the ones which are clogging the system. Those are the ones where mediations are not taking place. Those are the ones where mediation needs to be encouraged, because they are the ones who can't afford litigation. They are the ones who require mediation. They are the ones who are fighting for no reason. The mindset has to start changing from educating these private parties, that mediation can happen outside their communities also. The mediations can happen through the courts also, because when the mediation fails in their community, and when they go to the lawyers, they say, we've already finished mediation, I don't want to go through this mediation, the settlement has failed. For them, mediation means settlement. That distinction in their mind has not reached, that the settlement that happens in their community is different than the professional mediation that goes about. And the professional mediation, they have tricks, they have techniques, they have devices which they can use to help the parties to bridge their gaps. They can bring to the parties knowledge where their pros and cons are, bring them to their senses, make sure that the lawyers are out of the scene, so that some sense can be brought into them. But this is something which the private parties are not aware about. So they have, I mean, I have seen cases where parties have come for mediation, and when you begin talking to them about how they want to bridge the gap, they both stick to their claims, that this is my claim, I want this money. I mean, that's not mediation. And that happens a number of times. I mean, I know the judiciary wants mediation to be mandatory. The courts have been asking the parties to go to mediation as a mandatory process, especially when there are family disputes. But the parties don't want to do it. I mean, as a mediator, when the parties come before me, uh, uh, out of 10 matters, 9 matters, the parties don't want to budge from their claims. They only want to talk about what they have claimed. And yeah, I want that money, that's all. Or this is the relief that I want. So you give me that relief. That's my settlement offer. That can't be settlement. And the parties, even after 3 4 meetings, don't want to change, because outside the mediation room, their lawyers are advising them to do XYZ thing, or giving them the confidence. So the parties have to, at the end of the day, change. And so far as arbitration goes, well, I feel arbitration, we have uh, gone leaps and bounds, but it's always one step, 2 steps forward and one step backward by the legislature. If you and that's something that I have said that in many conferences before. Every time the judiciary does something, every time the Indian arbitration regime does something, or the legislature does something fantastic, we see a consequent amendment coming which takes one step backwards. Whether you take the 29A section, where the provisions were added and then subsequently deleted or amended, or whether you take the section, the challenge to the award, which is now based on fraud for that unfixed corporation judgment. So all these are like one step backwards. And then talking about the 246th law commission report at that time provided hell lot of things. and the parliament, despite the having the law commission report, did not amend it. And it's been probably the judiciary that is subsequently somebody in Supreme Court, some judge in Supreme Court realizes that this is required. And as doctor rightly said, it's better to be late than never. So some years later, the judiciary realizes that the 246th amendment, 246 report was correct, and the judiciary should amend it. And so let's implement it, and let's pass a judgment on that, and hopefully the judiciary will take care, the legislature will take care of it. So yeah, I mean, we are progressing, but it's always one step backward, and something that we need to stop doing by the legislature. So yeah, I'm little younger than Mr. Mishra and Doctor, but nevertheless helpful over here. And Doctor, I'm also a little academician, because I do write some papers, and I do give lectures in colleges around, and I'm doing my PhD. So yeah, I'm somewhere in the middle of Mr. Girish and Doctor. But it's a pleasure to be in the company of both of you.
No, it's always a very good mix. I mean, if you are doing PhD attached with academics, writing papers at the same time, taking up arbitration as a arbitrator, appearing in courts, I think that's a very good mix of practice, I would say. Because
Thank you.
academics we cannot rule out. Academic is something is the foundation of, unless you have academics, solid and sound academics behind you, behind your knowledge. I mean, you are more or less like a bail arguing lawyer. I mean, when you don't have any substance, you only stand in the court and you tell the court that bail should be given to you, and you don't have any substance to say. So, I mean, you have to have substance, and the substance in judicial practice is always the academics background, I would say. Either you write, you read, you follow some studies, keep on orienting yourself. That's something, and that's what you are doing, Mr. East Jan. I mean, that's really great. Great.
We are thankful to academicians like Doctor, who have always guided us in that direction.
That's really great. That's really great. The only
Our
thing
academia, also needs people like you, because in areas like this ADR procedural law, if we have academics who have never seen the court, they will not, or never have been. One of the advantages I have been also, I also fit in between, but I'm constantly also engaged in mediation. I've been appointed by various courts in at least section 89 referred, though my major area of mediating has been in family disputes and few commercial disputes, but largely family disputes. And I've also been a litigation lawyer and an arbitration lawyer for some time. So that's why I realized this part and parcel of the combination that is necessary. And I completely agree with Mr. Mishra. As you need in the bar, people who have this mix, we also need in our academics also people, right balance. And if that is done, then we can probably forge ahead in the
Yes,
right
and it
direction.
also points to a sort of law which we have, that you say that once how the full-time professor, you cannot pursue the court practice. These are something where actually some changes has to be brought in. I mean, to make this sector even better. The professor can pursue their the practice like in a doctrine of system which is there in France, that a civil servant can become a politician, president, prime minister, and he can come back again and join the service. So I mean,
Correct.
that makes the system working even better with more maturity than keeping a person entirely into a particular thing.
True.
So this is where even in the court roster, if you see, all the judges are given different areas to adjudicate upon. I mean, there is a system of roster. I mean, the point is that every judges, even if I am deciding as a judge, I am deciding bail matter or a criminal matter. It's not that I should know nothing about CPC. I should know absolutely nothing about arbitration, nothing about Companies Act. I mean, in order to give justice, even in a particular thing, I have to have the sound backing of almost, the most of the important things which matters in giving justice. So I should I think that there should be some system where the academics, those who are into the academics, should come and pursue their practice, and those who are into practice should also be given equally the sort of chance sometimes to go and take those some classes where they can add value in terms of giving education to the students insofar as practical aspect is concerned. So that's really, really good. I mean, other thing I would say, Dr. Anirban has raised the issue why only arbitration and why not mediation and conciliation have picked up the way arbitration picked up. I understand, and I would really seek, subject to your views also. I think it is the first thing is the enforceability aspect, because we have given arbitration award the value of being final decree of the court. So any disputing party would see that whatever process they adopt, whether it is going to give them finality or not. Now, one would not engage into a process where the outcome is not final, right? So normally, after the court system, if they have to look outside the court system, they would see to the arbitration process, because the Arbitration Act provides that the award is the decree of the court. So they find that yes, here is something which is coming as a final. But if you compare mediation, say for example, two party fighting for some small issues, civil matters or something, they sit in one particular room, take assistance of somebody, and there is a piece of paper signed by both the parties. Now, what exactly is the enforceability value of that particular piece of paper? If you see the enforceability aspect, it has absolutely no teeth of law. There is no backing of law. Even a person has signed that paper can come out of the room and say that no, I don't agree. Whatever I may have signed, I don't think
No.
that I'm going to
So,
honor that.
allow me to intervene.
Yes, yes,
The whole idea of this is that we need to take the law system out. So
yeah,
when we two persons agree, so there are,
yeah,
the problem with adjudication is that third party is deciding for them.
yeah,
But this is here a system where the two parties are deciding which is mutually beneficial. I do agree there are power imbalances, there are other factors. But
yeah,
here the two parties are deciding. So if they are able to decide what is good for them and come up with an agreement, why do we need a legal system to enforce? Of course, I understand human nature is I agree something, I come out of that room and I disagree. That is
yeah,
agree. But in the most of the cases, the involuntariness has largely been, because theoretically there is a difference that one is somebody deciding for you,
yes,
and here you are deciding for yourself. That's
yes,
the whole justification for having a lesser kind of an enforceable mechanism to the extent you have for arbitration or litigation. The reason is that people, when they voluntarily decide something beneficial to them, they will naturally comply with it. In
that you
fact,
may
I
call
think
that you may
compliance
call
is
as a
there.
settlement. Yes,
Yeah,
that you may call it a settlement process. Settlement
yeah.
can be between the two parties.
Yeah, but that has been misunderstood. This
Hmm.
thing has been misunderstood that there is no teeth because it is not having kind of a system like you have multiple appeals, etc. But the whole idea that this is not somebody deciding for you that you need to appeal it. This is
Yes,
something you are going to decide. This
yes,
whole idea, and I agree with Isha on this point absolutely, that this is where the parties have not understood. So the
yes,
education of the parties that he's talking, this is also one point that needs to be kept in mind, that it is to be conveyed to the people at large that there is a system where you are the central decision maker and not somebody for you, like in arbitration or litigation. I think this message is somewhere not being comfortably communicated by us only. We are only the responsible, and probably that is reason why societal skepticism, societal lack of acceptance is there. So
yes.
one of the ways of addressing is not legislating, but to promote more confidence by elucidating this view that this is a system where you are the central decision maker for yourself. sorry
Absolutely.
sorry I
No,
interfered
no,
with you.
absolutely, absolutely. You've actually added much value to this, and
Okay.
again,
Yes, yes, sir. Please go on. Please go on.
no. Another thing I would say that there are certain areas which has been held as non-arbitrable, or areas which cannot be mediated. Now, those are the areas slowly, for that matter, domestic disputes. The recent developments in judicial judgments have been that, insofar as maintenance, settlement, etc., is concerned, has been now taken into the arbitrable sphere and could be arbitrated. But still, larger areas are still not arbitrable. Uh, see, succession, the dispute related to succession is not arbitrable. So there are areas which has been, held as not arbitrable at all. I mean, those areas are something where one can really go to the court only. I mean, so there is a need that those areas are also liberated in that sense, I would say, and a party should be at liberty to even decide these succession issues. Like, to some extent, the deed of settlement is already a valid document where parties can sit and decide among themselves how much portion, which area, which room out of the the joint property they are basically dividing among themselves. That the deed of settlement has been taken as a valid document, and which could be enforced. But the point is, that is something which is settlement. I mean, settlement is something where the parties, disputing parties themselves, sit together and decide and settle without any interference of any third party like arbitrator or mediator. Whenever there is a third party interference, there only we say, the largely when we say alternate dispute resolution mechanism, we are basically referring to those mechanisms where third party sits as either as an arbitrator or a mediator or as a conciliator to decide the dispute. But when it is settled, I mean, the settlement could be between the parties, disputing parties themselves, and to some extent, even the succession aspects have been taken as a valid, the reconciliation if there is a deed of settlement with the parties. Now, where I was there, I was saying that in case of mediation, a mediator sitting and settling the dispute and resolving the dispute with the parties, there I see that the kind of teeth with the arbitration act provides to the arbitrator, there is no such power and enforceability, the sort of thing which is provided to a mediator. So this is what is the difference why people normally do not opt mediation as the alternate dispute mechanism, and they go for arbitration because they think that it is going to be a final award. I can go and have it enforced. But in case of mediation, probably we may not have those rights available with us. So, of course, the disputing party will definitely not normally go to those areas of dispute resolution mechanism which do not provide finality to their disputes. So, this is one reason why arbitration has picked up comparatively more in last decade and 20 years than the mediation and other aspects of this.
Thank you, everybody, for your views. So, taking the conversation forward from something which were discussed earlier, we have a lot of other techniques as well in alternative dispute resolution, like early neutral evaluation and even expert determination. But these methods have not surfaced yet in the Indian sphere. So, what can we as alternative dispute resolution practitioners do in order to ensure that these methods are also not ignored and we can make the best possible utilization of these methods?
Uh, Manor, you are right. Uh, Expert determination and early neutral evaluation has not been developed effectively in India. In fact, presently it is negligible as compared to the amount of arbitrations or mediations that are going on in India, let alone litigation. And now, with respect to expert determination, there is still an excellent scope in India because, as the number of arbitrations are occurring, the need to hire the experts for determination of technical experts is increasing. And unlike other jurisdictions in India, still does not have many arbitrators from specific fields. In India, arbitrators are still primarily the lawyers, and with rare exceptions, they belong to another field. But I feel that once there is a trend of hiring experts in arbitration proceedings, to determine particular facts, there will be a corresponding effect that there will be more and more expert determination methods used as an alternative ADR technique. So you'll have to really build that trend that you require experts in arbitration before you reach the stage of hiring expert determination as an ADR technique. We're still at the first stage, and it's going to take some time for us to travel to the second stage as yet. And in fact, what you need to do is get more arbitrators from those specific fields rather than only lawyers, and train them to be arbitrators. Give them the experience of being arbitrators, make them sit along with experienced arbitrators, and that's how you slowly go towards expert determinations. And so far as early neutral technique, the early neutral evaluation techniques go, I think it's I mean, I don't know if our viewers are aware. It is basically an advisory and evaluative form of alternative dispute determination. The neutral party evaluates the facts, it looks at the circumstances, issues, and then gives its opinion or insight on what the party should do. But this is a non-binding process. I mean, if what Mr. Girish is saying is that the mediation has no teeth, this has even far lesser. I mean, this doesn't even have a mouth to open, because it's completely non-binding, completely voluntarily, and it's not something that you can refer in the courts also. uh, so in the Indian litigation culture, this is less likely to be developed in the coming future. I mean, even if you have a legislature to support this, it's less likely to develop. I mean, the amount of varying opinions regarding a dispute under the Indian laws is so much that every neutral evaluation would likely come to a different conclusion, and this will all be prima facie, without evidence being laid, without any rules of evidence being followed. So this is just going to be like seeking an opinion from uh, from a retired judge as to what is the likely outcome of the litigation that is there before him. So in my opinion, though expert determination as a procedure and to settle the dispute is a is something which has a bright future, and maybe sooner or later it may pick up a trend in the country like India. But on the other hand, this neutral evaluation method goes early neutral evaluation method goes, it is less likely to be developed as an ADR technique in India, at least. I mean, and in other cases, the- you know for both these techniques, what you require is not by way of legislation. It is more of by way of recognition in courts, because mediation and arbitration developed in India after the recognition from courts. For example, the example that doctor gave us about emergency arbitrators. No matter what the legislature does, I mean, we had the 246 law commission report, which provided for emergency arbitrators, but did not have any impact in India. But it's only when the judiciary started recognizing, when the Supreme Court recognized it, that there is an emergency arbitration. There is there is a cantena of judgments after that. There is a huge debate. There is a discussion. There are papers written. The law colleges are discussing about it. The students are discussing about it. The parties are becoming aware. The newspapers are reporting. So unless there is recognition of these techniques of expert determination, or these early neutral evaluation, the courts are I mean, it's not likely to develop unless the courts give recognition to it. And I mean, for instance, if the expert determination is required to be binding upon the parties, the courts will have to accept and enforce the conclusion arrived at by the expert determination. Is that likely? That's going to be a big question. We have court commissioners' reports which are challenged. We have handwriting experts' reports which are challenged. No party accepts it, and the courts require the parties to be the handwriting expert or the court commissioners to be examined sometimes. So I don't know how much of the expert determinations will be accepted by the courts or enforced by the courts. Until that does not happen, I don't see this technique developing anytime sooner. Similarly, when you look at the early neutral evaluations, it requires encouragement from the courts to accept those evaluations. And I mean, if you practice in the court, you would I mean, you would be aware that the courts will not generally accept evaluations and opinions given by even retired judges. And until such acceptance happens by the courts, it is difficult to ensure the progress of these methods. So yeah, I mean, uh, I'm being very skeptical about both these methods, but this is something that's a fact right now. I mean, without the court's recognition, we can't do anything about
Yeah. Thank you, Mr. Ish, for your views. Do any of the other speakers have any views on this?
I will only add, I entirely agree with what Mr. East Jan has said. The reason why these new things like expert determination or neutral evaluation, etc., is not actually coming on the ground is that the entire arbitration process in India, at least, has been hijacked by the lawyers. I mean, basically, and the retired judges. Most of the appointments are ad hoc appointments, uh, and the result of this is that what exactly we see in the courtroom, the same things happens in the arbitration room. So, the lawyers use the techniques of the courtroom only. Like whenever there is a sort of cross examination or filing of papers, reply, rejoinders. So, we being a lawyer practicing in court, having our experience in practicing in court, so say, for example, I have 20 years, 23 years of experience. People may be having, 30 years of experience, 10 years of experience. So, what exactly is the experience we are counting? We are counting the court experience. What exactly is needed now is the experience in arbitration. So there has to have in order to bring all these changes, we have to recognize a new breed, I mean, a different breed called arbitration lawyers or arbitration practitioners. Why should we say arbitration lawyers? Arbitration practitioners. So arbitration practitioner and arbitrators. Arbitrators need not be retired judges. Arbitration practitioners need not be lawyers. So unless we make this particular change, the shift in the whole attitude, these new techniques, new things, which is otherwise which are otherwise very popular abroad outside India, it will be very difficult to bring in and make it popular in India, basically. So the first thing is that slowly and gradually these arbitration institutions have to be given more importance. Like 2019 Act itself has now recognized that the Arbitration Council of India, designation of arbitration institutions. Then the court also the grading the arbitration institutions and the designating them to use the appointment process instead of court appointing the arbitrators. So more and more these arbitration institution coming in and taking the ground insofar as arbitration is concerned, there is less likelihood that these new techniques, effective techniques, will come into place practically, I would say. And at the same time, I would say that even those lawyers who practice arbitration, there is a need. Let me tell you what is happening today. I am a lawyer. In order to get the client, my first approach is to see what kind of matter is the client is bringing. If client has domestic violence, I would say I am an expert of domestic violence. If client of arbitration comes, I say I would start saying I'm the expert arbitrator, arbitration lawyer. Somebody comes and says that I have got a property dispute, I start saying that I'm the expert property dispute lawyer. So actually, what is happening is that there is no grading even among the lawyers. I'm saying the lawyers also should have a grading. What exactly? I mean, I practice as a judge. I'm a different person. I may have to judge. I have to have a wider understanding of entire the thing. I mean, which may be a dispute or something. But as a lawyer, if I have to actually give properly help a particular person who is aggrieved, then I have to have expert in that particular area. Now, taking this discussion further, I should say that there has to be a need right now to recognize the arbitration practitioners, so that the arbitration practitioners can bring in all these new changes, whatever changes which are taking place outside and which can add value to the arbitration process. Even the arbitrators who are of different the expertise come from different the fields, like engineers, architects, designers, IPR expert. I mean the arbitrator can be from any field for that matter. It is like dispute could be from anything, right? Similarly, you need expert people to deal with that particular specific dispute. Today, what is happening in court is that a particular judge decides whatever dispute comes to him, whether it is a dispute relating to engineering defects, or dispute relating to the architectural defects, or dispute relating to some chemical, a problem and issues. Since the dispute has come to the court, the judge has to decide. This is where the arbitration is going to add value, because in arbitration sector the parties feel that they have the liberty, if they feel that they have got a liberty, to put an expert of that particular field as the arbitrator, and they also have the liberty to engage a arbitration practitioner who can actually handle that particular thing. Then the whole the approach is going to be different, and then only we can see that these new approaches, as you were just discussing, will come. And insofar as court recognizing these things are concerned, courts are coming slowly and gradually to a point where they say that the court cannot modify or change the award. Now, this is the big development, I would say, because in the sense that, what happens now, what is the treatment of award in the court today? If court cannot modify a particular award, that would mean that either the award is entirely accepted, or if award is entirely rejected. So somehow the courts have shown their, the intention that they are not going to, really, adjudicate upon what has been already adjudicated upon by the arbitrator. So I think in that case, if an arbitration institution and an arbitrator or arbitration practitioners has already adopted certain techniques like expert determination, evaluation, etc., etc., I see no reason why court will not really respect those things, because court has already said that they will not modify. And unless those use of new techniques amounts to a fraud or amounts to some kind of biasness, I think the court will not interfere with with the award if these techniques have been used. In sum and substance, I would say that uh, there is a need to change the whole concept of ad hoc arbitration to institution based arbitration. Moment we shift this, but make this particular shift, then the arbitration institutions are definitely going to bring in all these new changes put in place, and they will definitely assess the parties to have these new techniques added to the procedure, because maybe arbitration institution may have this in their rules itself, where party may appoint, and party may avail these facilities. And the since there is a rule, the arbitrator is equipped to understand and appreciate all these things and deal with these things, then definitely the parties adopting arbitration as the dispute resolution mechanism would be in a position to use these new techniques, and court will also appreciate those things and will not interfere with the award, which is based on the techniques and the procedure where expert determination, valuation, etc. has taken place.
Yeah, thank you
I
for your views.
want to
Yes,
add,
Dr. Anirban.
I just want to add one or two small things.
Absolutely,
Uh,
sir.
I agree to the views of my co-panelists completely. I think what we need to see is that I use that word. ADR's function is not just settlement of dispute. ADR has a much more wider role. And if you consider all these are forms of alternative, the word alternative dispute resolution is some itself a misnomer. What do you call, why do you call it alternative? That means you have something which is like the must and the others are alternative. So I don't call them, I call it alternate or appropriate. So I think the word appropriate dispute resolution for me works better. So choosing the right horse for the right course. And the second is, if you look at from this way, then you see the function of this appropriate dispute resolution widens. And these functions are dispute prevention, dispute processing, and dispute management. And each of these dispute resolution systems can be characterized in this. Now, the things like early neutral evaluation or expert determination to some extent, have different functions to something called dispute resolution. They may be more of seeing dispute prevention, dispute management skills. Now, what you do in a early neutral evaluation, you evaluate how strong is your case, what are the right sides and the left sides, on this, and then you take decision in terms of how do you proceed with that dispute. So it's more of a strategically, evaluation, and there is a lot of empirical data to support that this has worked well, because in US, almost out of 100 suits filed, 90 is negotiated. The reason is that there is a pre-trial and pre-processing of these cases, or disputes somewhere, and these processes play an important part in this. Now we have to look it from this holistic approach of ADR, then narrowing that, it's just a technique of resolution of dispute. So we have to first change the term to what we call this. We call it anymore as alternative dispute resolutions, or we call it dispute resolution and management techniques. I would say that we should now start, our vocabulary changes. So that's the first point I wanted to add. And another point that I want to add is, it's not, again, we have to emphasize this in our, sort of, from the grassroots education model. How much of our courses talk about all this? How much our, lawyers are exposed to all these techniques? Similarly, continuing judicial education or legal education, how much of these are talked about? So when we see somebody, when you go to a, it's this panel looks like people who are into really up level litigation, so they are all working in that. But if some of us who have exposed to most distant areas, district courts or subordinate courts, where also there are needs, because maximum black backlogs are there. Now those lawyers, those judges, they don't have at all exposure to all this. So how do you talk to them? How do you train them? How do you convince them? It's better, to, and they, for them, I have seen, for them, expert means, that Gram Panchayat ka leader. And that is not the expert evaluation you are talking about, right? So you need, appropriately training to give them understanding. And that's where, unless that is addressed, that's why for me, what I feel that more than legislative and judicial change, we need to change our curriculum. We need to change our vocabulary. We need to change our training. And we need to, I agree with Mr. Mishra on that point completely. We have to have a completely different cadre for arbitration. And I will also say we separate that from the non-adjudicatory ADRs. For mediation, conciliation, and all, we are another separate cadre, because the skills are very different. They will tell you. They are regularly into mediation and arbitration. They will tell you the skills that are used for mediation, conciliation, where they will approach, they are completely different from arbitration. So we need further distinction in the cadre. And then we have to have a separate accreditation, separate training, separate skill building. And that's why I said 42 hours, can you prepare a mediator? And I'll tell you, 90% of the people who are mediating, they're all 42 hours trained mediator. And you are expecting them to understand the psychology of the dispute and then get into interest and get into, all this principle-based negotiation model. 42 hours, what you give them and call them their expert in mediation. So this has to change. That's where I just wanted to add.
Yes, thank you. So, due to shortage of time, I will place both of my questions now, and the panelists can discuss. And Mr. Ish Jain can, I think, take it up first since he has other commitments as well. So, my first question is that technology is going to be at the epicenter of commercial activity. So, and Indian law has not been able to match up to this. What would you say, for instance, let's say arbitrability of a smart contract dispute? Would something like this be recognized by Indian law? And secondly, what can ADR practitioners inculcate in their day-to-day lives so that more younger practitioners are empaneled as arbitrators or mediators? Or is this something which shouldn't be done because of lack of experience or maybe some other factors?
Okay, that's quite a mouthful of questions, but let me try and answer them one by one. Smart contracts are simply programs stored on the blockchain that run a predetermined conditions are met, and they're typically used to automate an execution of an agreement, or so that all the participants can immediately ascertain the outcome, and there is no involvement or time lost in between. And this is an automated workflow, and it triggers the next action when the conditions are met. Now, it is incorrect to say that the Indian laws are not equipped to deal with sophisticated technology. I mean, so far as the smart contracts go, I mean, they provide for dispute resolution clause. The question of arbitrability does not arise because this is fairly simple. The tribunal has to decide the question of arbitrability. So far as there is a clause provided in the contracts, the dispute is arbitrable. But if you're asking about any reform that is required to enable the arbitrability of smart contracts, I don't see that there is the present laws are well equipped to deal uh, with anything that refers to an arbitration clause or a dispute resolution clause in the contract. Now, the problem is not the laws that are existing in the country, but the experts in that field, and how many lawyers who are specialized in that technology. So if you look at, for instance, in aviation, in space law, or any other technological field, how many lawyers do we have in that field uh, who can actually ascertain to be an expert? And if you count, there'll be handful of lawyers in the country who actually practice in this area of technology, aviation, telecommunication, or space. Now imagine the limited number of pool of arbitrators that are there from the country, where the lawyers are so limited, who have experience in technology, aviation, telecommunication, or space law. Now, I say this because I'm writing two chapters right now for an international publication, one on arbitration in commercial aviation disputes and another in arbitration in commercial space disputes. And the idea that I'm trying to draw in both these chapters and both these discussions is, I mean, it's not the law that is requiring focus. It's There are two problems which I've identified in both the chapters, and once it's published, I'll probably circulate it to my colleagues. But the problem that I've identified in that is the lack of arbitration center for dealing with such disputes, and specialized arbitrators with an experience in that particular field. Today, how many arbitrators are there who have studied space law, or have studied aviation law, or have studied technology law? We have Justice Manmohan Singh in Delhi, who has good knack over technology, and I have a few arbitrations before him. But that there was a very technical arbitration which was there, and in that we required him to explain of how the whole website operates, of how orders are placed on a banking website, and how it relates to the computers, and how the computer responds. And there were multiple parties involved in it, and trust me, it took almost three hearings and three dates to explain somebody as tech savvy as Justice Manmohan Singh to understand of how this technology operates. So we presently lack arbitrators who are having knowledge in these particular fields. So technology is not the problem, the law is not the problem. It's training those arbitrators in that particular field is the problem. As Girish was just pointing out, this is the problem with not just lawyers, that the client comes to them and they claim to be experts in those fields. It's a lot to do with arbitrators also. The courts don't realize that the arbitrators are required to be selected based on their speciality. Arbitrators are selected just because the parties have chosen, or because the judge feels that this arbitrator is well equipped to deal with this quantum of disputes. The nature of dispute has become irrelevant somehow, in this process. Even the parties don't want to look at the nature. From personal experience, this is not something that happens in the international regime. I had an aviation law dispute in London in 2018, and we had interviewed six law firms. And every law firm, when we interviewed for the client, had this uh, discussion on whom to select as an arbitrator when that dispute is done under the ICC arbitration rules. And they had a list of arbitrators, and they had methods of interviewing the arbitrators to ascertain who had the expertise in aviation law before they would appoint an arbitrator. But this is something that is lacking completely in India. So uh, the question may seem very relevant, that whether we have laws to support that technological background or sophistication in disputes. But it's not the law that is the problem. It's what do you do with the law if the arbitrator does not understand the technology, or it does not understand the law, if he's not studied the law? So we need to address that question. Now there is so obviously I don't know the exact angle of the question, but there is another angle, whether disputes can be resolved through blockchains or smart contracts. So I don't know if Manor was referring to disputes being resolved through these methods, but this is something which is impossible. So no we can I mean, how do you fit it in an algorithm or a mathematical model, or codes? Whilst it is argued that the benefits of blockchain technology generated in arbitration is that it is free of human minds, and it's therefore free of human error. However, the purpose of arbitration is to provide autonomy in selecting the rules, in the laws, and in the procedure of arbitration. At the same time, the international arbitration regime has, from time immemorial, recognized the authority and power of the arbitrators to determine the procedure or the substantive law to be applied during an arbitration proceedings. This is free will inherent in the arbitration proceedings. I mean, the blockchain platforms cannot replicate this free will of the arbitrators or of the parties. And whilst blockchain can provide for uh, I mean, would provide resolution of disputes free from human minds, but arbitration is all about human influence. And as an arbitrator, I can tell you that uh, you know you can't have a stringent or a straitjacket rules uh, in arbitration. I mean, as you have in traditional litigation. In fact, the entire purpose of having arbitration is so that you're not governed by the CPC and the CRPC, or you're not governed by the Literal Codes of Evidence Act. Obviously, that is now debatable, because whether evidence falls in substantive or non-substantive is another question. But the whole idea of arbitration is so that you don't have to apply those rules. So you can't have blockchains to resolve arbitrations, or decide the disputes. And arbitration allows the arbitrators to focus on justice delivering system, rather than the procedure uh, in reaching that justice. Therefore, you will notice that an arbitration award is not capable of being challenged on many grounds. There are very restricted grounds on which you can challenge an arbitration award. What the court looks at is whether there was a fair play, and whether uh, sorry, whether there was a fair play, or whether public policy was breached. It does not talk about whether laws were followed, or whether this method was applied, or whether certain rules were followed. So when the courts recognize, even the entire intention behind the arbitration legislature is that it's free will. Now, having said this, arbitration, as an arbitrator, I feel that technology is useful to uh, to improve the efficiency, to improve the sophistication, to improve the speed of, and make the arbitration more effective. So, as an aid to an arbitrator, technology definitely is something that we can use. Just to answer your first question, you know, I don't think there are any reforms required to accommodate, uh, you know, how these technological sophisticated disputes can be resolved in arbitration. Obviously, as I said, we need to have arbitration centers, and you need to have arbitrators specialized in those fields. But this is something which is dehors of law. This is something which lawyers have to do, which the institutes have to do. So I mean, this is something which is internationally not done as yet. So it's not that we can do something about it in India. For example, it is just recently that I think the Gujarat University has started the Maritime Arbitration Center. So something of that kind can be done for technology, can be done for telecommunications, can be done for aviation, can be done for space related disputes. And that is something that I strongly argue even in my chapters that I'm writing for the international publication. Going to your second question about young practitioners now, as compared to Girish and Dr. Anivaran, I'm a young practitioner. Uh, So I think I'll be able to tell you of what hurdles are faced as a young practitioner, and how it goes about. I've almost finished 15 years in practice now, but I had faced this. So I was appointed as an arbitrator at the age of 29. So that's quite young. But I'll tell you of how, what I think. I think that all this young practitioners are precluded from being empaneled in an ADR institute is is because they lack procedural experience in the field of ADR. The empanelment institute ought not to depend on the age of a practitioner. So when we call young practitioners, we are normally referring to the age. When I was appointed as an arbitrator for the first time, I was 29, and questions were raised about the age. But it's not the age that matters. It's the number of years that you've practiced as an ADR. For instance, a person maybe at the age of 45 and practice as a lawyer for the rest of his life, but has hardly spent 6 months in the field of ADR. I mean, that person cannot be entitled to be on the ADR panel because he has no experience in that as yet. He can be a practitioner, but he can't be on the panel of ADR institutes. On the other hand, a young practitioner, at the age of 29, 30, may be entitled to an ADR institute if he has already spent about the last 8, 10 years in practicing in the field of ADR. Because he has more experience in ADR, and what arbitration requires is practice. It's 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 beyond theory. And with all due respect to doctor, uh, you know when I said I give lectures in colleges, my lectures are generally focused on what ADR practitioners need to do in real life. And I do it along with the people in the academics in the college who are teaching the theory, and to supplement them, I teach them the practical aspects of how what has been taught to them in the lectures can be implemented practically when they come in real life. So therefore determining factor is not whether they have diverse set of skills and talents. Sorry, the determining factor should be whether they have diverse set of skills or talents, uh, and not their age. This is a scenario which has changed it has not changed in India overall, but I can say that about Delhi and Bombay, where both places where I practice as an arbitrator, that this is something that I have seen being implemented by one or two judges in both courts. Especially my first appointment was from Bombay High Court, so I know that Justice S.J. Kathawala from Bombay High Court had appointed me in my first arbitration matters, and obviously he has in the last 5, 6 years before he was elevated to the division bench, appointed several young practitioners as arbitrators. And the only qualification that he had was that he would, based on their court appearances, verify their diverse set of skills and talents. And he would not look at the age. He didn't bother whether they had 3 years of practice, or they had 10 years of practice, or they had 50 years of practice. He focused on what was before him, and how the practitioner had argued, or how he had represented himself, or whether he had sufficient knowledge in the field of arbitration. Similarly, I have seen these practices by certain judges in Delhi High Court, but this is not something that I have seen with the judges in the other high courts as yet. And that's something that we need to encourage more if we want the true ADR practitioners to be empaneled with institutes. It's not just, even in Bombay and Delhi, it's just a few judges. We need more and more judges. We need all the judges to do this, if this is what we really intend to do. Now, having said this, it's very important that while we encourage practitioners to be empaneled in the ADR institutes, it is important at the same time for these young practitioners to gain the diverse skills and talents in the practical world in arbitration. Merely studying theory or masters or PhD in arbitration, uh, dehors of acquiring the skills and talents is not sufficient. I'm not saying that you know studying the theory or masters or PhD is not important. I have myself studied theory. I have myself done masters in arbitration. I'm myself doing PhD in arbitration. So, not to suggest that that is not important, but that cannot be the criteria for you to be empaneled as an arbitrator within institute. What you require is a set of skills and set of talents which can only be acquired by practicing in that field, practically practicing in that field. And this is something that the young practitioners should know. Without this experience, including, is my voice echoing?
No, I think it was for a brief moment, but no, not now.
Okay. Without such experience, including young practitioners in ADR Institute would reduce uh, the quality of the ADR Institute in providing the justice to the parties, and therefore the ADR institutes normally are generally not so inclined to include the young practitioners to be impaneled. I've been impaneled with almost 25 institutes, and I still face that hurdle of, "Oh, you are 40 and you're below 40, and why don't you apply to us next year, and we will be able to admit you." So in the arbitration world, somebody below 40 is still called as a young practitioner, which is disheartening, and which is something that needs to change. That can only change by young practitioners proving their mettle, going through the interview process, actually practicing in the field, getting appointed as an arbitrator, performing in their arbitrations, putting that extra effort in following the rules, in passing awards which are fair, which are just, which take into consideration all the laws that are applicable, and which, where the parties don't feel wronged. So something that the young practitioners should take a cue from there. That's all. It's
Thank
a
you.
very because you asked me two questions, I had to, you know
Yes, yes, no, no, I understand. Perfectly understand.
but I'm up for discussion with doctor and Mr. Mishra.
Yes, if the other speakers have anything to say, please go ahead, by
So
all
I
means.
I I entirely agree with Mr. Ishjan when he says that we actually do not need as such the law as such to be passed to for the technology to be used in arbitration process. The technology which is there, all we need is that the arbitration practitioners, the arbitrators should basically train themselves and should be able to use those technologies which are already there. And more and more we have a trained arbitrator, trained arbitration practitioners, uh, even in those technology aspects. I think, I mean, they'll be able to use it, and there is already a law. The IT Act. We have all the other acts which deal with evidentiary value of things. So we already have sufficient laws, and more particularly, if you see the approach of the court at the system here, even if we do not have a law, if there is a law outside, that law also has the persuasive value. We can always suggest the court that there is a law in the US, or there is a law in Australia for that matter, which deal with such kind of a thing. And we say, if we do not have any such law, that then in that case courts will often see how that law operates. And the courts have power over here to if there is a vacuum, then in that case Supreme Court can lay down the law also at times, and the legislative law can follow. So those things are already there, so we do not have actually as such we are in a as such in a a kind of situation where we urgently need any such law, new legislation. Secondly, of course, that also takes care of the fact that I also understand that there has to be trained arbitration and trained arbitration practitioners, trained arbitrator, and there is training needed as such. Thirdly, I would say, see, for every development, we always look outside. I mean, if there is other countries following, then only we will follow. There are certain things where we can also initiate certain things. Like, for example, in case of aviation, the pilot's experience is counted in terms of number of hours. The particular flight, the pilot has flown the aircraft. So they keep on adding the number of hours, and they, whenever they prepare their the CV, they basically write the number of hours they have flown the particular aircraft. Similarly, what we need also is that there has to be a data, arbitration practitioners data maintained by any agency, where it is basically objectively maintained that a particular arbitration practitioners have conducted, say, 10 arbitration proceedings or 15 arbitration proceedings, and number of higher is the number of arbitration proceedings conducted as an arbitration practitioner, that should sound as a sort of credential, that should be used as a credential to basically judge a particular arbitration practitioner by a disputing party, whether to be used or not to be used, whom to be picked. So it should not be left to arbitration practitioners to whatever number of arbitration cases to say that he has handled, because there is no as such mechanism to verify whether that is correctly stated or incorrectly stated. So if an arbitration practitioner is connected with a particular arbitration institution, then in that case, these data could be maintained, and uh, the the facts could be verified whether what is being represented by a particular arbitration practitioner is correct or incorrect. So these kind of objectivity. Similarly, I mean, in case of arbitrator, the data could be maintained with regard to the expert area a particular arbitrator may be expert in, and number of cases arbitrator has handled. So there could be a little bit of objectivity and transparency which can be put in place by adopting these the things, and also by using the new techniques, so that same cannot be fudged, same cannot be, say, maneuvered, and any third party or disputing party wanting to know about me as an arbitration practitioner could find out what kind of practice I have in arbitration, how many arbitration cases I may have handled. So, if there is such data being maintained, then I, as an arbitration practitioner, would be more and more willing to go and report a particular practice which I may have done, or a particular case which I may have handled or concluded, to be added in terms of my number of arbitration done. And any party approaching the arbitration institution or agency could find out if I could be selected as an arbitration practitioner or as an arbitrator or not. So these things, these are the areas where technology can play a role, and uh, there is also a requirement for training, etc., to be given to the arbitration and arbitrators. So I agree entirely with what Mr. Eastden has elaborated, and he has given a quite a detailed, word on
Yes,
this.
thank you. Anything, Dr. Anirban?
No, I don't want to add. Let's move to the next question.
Yes, so I think we are done for the day. There are no more questions.
Yes. Okay.
Uh, so I'm extremely thankful for all of to all of you for spending your valuable time with us in these sessions, and I'm sure we've discussed a lot of points, and the viewers have learned a lot from this. Uh, Thank you, everybody.
Thank you very much. Thank you,
Thank
Dr.
you, Manoj.
Anita. Thank you,
Thank,
Eastden ji.
thank you, Mr. Mishra. Thank you, Mr. Jain. Thank you,
Thank
Manohar.
you. Thank you, Dr. Anirban. Thank you, Mishra. Thank you, Manor. Thank you for having us on this panel, and it was a pleasure. And stay safe.
Yes, all of you. Same.